Law and Equality Symposium on the 2023 Minnesota legislative session. This specific panel will focus on the passing of the cannabis bill, decriminalization, and expungements. And we have 4 panelists here today to share their perspective and knowledge of the recently passed legislation. So first, I'll just give a general overview of the cannabis legislation. So on May 30th, 2023, Governor Walz signed legislation that legalized cannabis, provided for the expungement for resentencing of certain cannabis convictions, established the Office of Cannabis Management's regulated industry, and created a 10% tax on recreational cannabis. The legislation also allows sales for legal adult use cannabis in Minnesota in 2025. It includes grants for cannabis growers, substance use treatment, recovery and prevention, and communities that have disproportionately suffered the effects of cannabis prohibition. We have the chief author of the legislation in the Minnesota State Senate here today, Senator Lindsey Port. Senator Lindsey Port has served in the Minnesota Senate since 2021. She represents District 55, which covers the communities of Burnsville and Savage. She is a longtime resident of Burnsville, where she lives with her husband, 2 daughters, and their 2 puppies. Senator Port is a chair of the Housing and Homelessness Prevention Committee, and in 2023, she championed a historic $1 billion investment in safe, affordable housing for all Minnesotans. She is the Senate chair of the Reproductive Freedom Caucus, which leads legislative efforts to secure bodily autonomy and reproductive freedom. And as chief author of the 2023 Adult Use Cannabis Legalization Bill, Senator Port had the once-in-a-career opportunity to legislate a new government agency, regulate a formerly prohibited industry, and prioritize social equity within Minnesota's new industry. Senator Port also serves on the Elections Committee, the Transportation Committee, and the Energy, Utilities, Environment, and Climate Committee. We also have Hennepin County Attorney Mary Moriarty here today. Hennepin County Attorney Mary Moriarty is the elected Hennepin County Attorney. She was sworn in January of 2023 and previously served as the Hennepin County Chief Public Defender for 6 years. As the County Attorney, she serves as the Chief Executive of Minnesota's largest public law office. She grew up in New Ulm, Minnesota. Her mother, Linda, was an English teacher, and her father, Patrick, served as Itasca County Attorney from 1963 to 1969 and was later a public defender in New Ulm. After high school, Hennepin County Attorney Moriarty attended Macalester College, where she played softball and basketball and majored in history and political science, earning her Bachelor of Arts in 1986. In 1989, she earned a Juris Doctor from the University of Minnesota Law School. After clerking for Hennepin County Judge Kevin Burke, she joined the Hennepin County Public Defender's Office. Early in her career as a public defender, she argued a case that would eventually go to the U.S. Supreme Court. A Minneapolis police officer had patted down a man and claimed she could feel through the man's jacket that a small lump of crack cocaine justified the search. She argued that it would have been impossible to identify the lump as drugs. On June 7, 1993, the High Court unanimously agreed, ruling that the officer had exceeded the limits of a legal pat-down. The case, Minnesota v. Dickerson, established what is referred to across the United States as the plain field doctrine. In 2014, after spending 25 years as a public defender, she was selected as Hennepin County's first female chief public defender. As chief, she oversaw some 45,000 cases per year and managed a staff of 140 attorneys, over 70 support staff, including investigators, dispositional advisors, paralegals, IT personnel, legal office assistants, and law clerks. An independent evaluation from the National Center for State Courts stated that under her leadership, Hennepin County had one of the best public defender offices in the country, one that was as successful as a private law firm. She retired from the public defender's office in 2020, and during the trial of former MPD officer Derek Chauvin, she provided on-air legal commentary and analysis to various local and national media outlets, including MSNBC, BBC, CBS, Fox, and TPT. She was elected county attorney in 2022, and as county attorney, she manages a staff of over 500 people with an annual budget of $70 million. The county attorney sets policies and priorities for prosecuting criminal cases, oversees child protection and child support cases, and provides legal advice and representation to county government. Hennepin County is the largest local government in Minnesota and has $2.6 billion annual budget with 9,000 employees. We also have here today Julia Patach. She is a 2022 graduate of the UMN Law School. She is currently an Equal Justice Works Fellow at the Immigrant Law Center of Minnesota. Her fellowship is designed to combat racial injustices caused by the disparate impact of the criminalization system through collaborative litigation and education for non-citizens who urgently need to overturn unjust convictions. In her role, she represents immigrants and refugees with criminal records, especially those who would be good candidates for post-conviction relief and have long periods of residence in the community. She also engages in advocacy efforts to increase access to immigration-related post-conviction relief in Minnesota. We also have Daniel Suter, from a housing attorney from Homeline. He's a 2022 graduate of the UMN Law School as well, and he serves clients on the hotline at Homeline and working on rent stabilization issues in both Minneapolis and St. Paul. He joined Homeline during his third year at the University of Minnesota Law School through the state's public interest residency program. So thank you all for being here. We're going to just start off with a few questions. I'll switch over here and also give the mic off. So that mic, I'll turn off just so it amplifies. So our first question is going to be for Senator Port. And basically, we just want to talk about how 2023 was such a busy legislative session, and so what it was like to try to include the cannabis legalization and why was it a priority to get it done?
Yeah, that's a great question. Hi, everyone. I'm Lindsay. 2023 was a busy session, probably one of the busiest in the history of Minnesota. I was really lucky with the cannabis bill that a lot of work had been done prior to an opportunity for us to move it in the Senate. The Minnesota House had been working on this bill. They had had hearings the prior year, moved it through all the committees, had really learned a lot, had had conversations all across Minnesota, so we knew a lot. And I inherited a great starting version of the bill. And then we had 4.5 months to get it through 15 committees on the Senate side, and really, because it hadn't had a hearing in the Senate, educate all of my colleagues on the importance of the bill, on why it needed to pass, and answer all the sort of really ingrained questions or fears people had about legalization. I think, for me, taking on this bill was a priority because prohibition was a failed system. It did not work. It had disparate impacts, particularly on communities of color. It pulled apart families. It hurt job opportunities, housing opportunities. It wasn't working. And I knew that if we were going to legalize, that full legalization along with decriminalization and expungements was required. And I was very worried about us doing it piece by piece and saying, oh, well, let's decriminalize, but not legalize, which would have disparate impacts again. So that was really my priority for it, and we were able to really bring all of our colleagues along by telling that story. And I think, the story tells itself. There are so many people whose lives have been affected by prohibition, by cannabis arrests, records, things like that, that it wasn't a hard story to tell in Minnesota because it's true for so much of our residents. And so we made it a priority. It was, my legislative assistant Courtney is here, who helped us schedule 160 meetings, and really, we took it really seriously. This was the priority of the session for me, and really felt lucky to be able to be a part of the team that got it across the finish line.
Thank you for that. You mentioned kind of the effects that everyday people felt, and you felt like a need to get this done. So that brings me to Hennepin County Attorney Moriarty. Kind of how has your office reacted to this legislation, and what are you doing and your office doing surrounding this legislation? Because we know you're in enforcement, but how does that affect the people whose lives are affected by this?
And I want to thank Senator Port for this legislation. It was long overdue. And I think, you have to look at it in a historical context in terms of the criminal legal system. And I think many people find it hard to believe that, we all have heard about the war on drugs, right? War on drugs. But what was that actually about? And I think the thing people are surprised about was that John Ehrlichman, who worked for President Nixon, actually said the war on drugs was about black people, essentially. Hippies and black people, he was actually quoted as saying. It had nothing to do with actual drug policy. It had nothing to do with addiction. And so they picked products like marijuana, which has a disparate impact, to criminalize. And as Senator Port said, it has had huge consequences. People get convicted, people have gone to prison, people have gone to jail. They have a hard time getting licenses because of all of the consequences. When I came into office, I already knew, this legislation was probably going to go through, but I also knew we as an office needed to have different priorities. And that was certainly not marijuana. So we have a policy change. We don't prosecute marijuana, and we didn't prosecute marijuana cases even before the legislation, unless, and we tell law enforcement this, we don't have a blanket policy, but if you could tell us it's marijuana plus something else, marijuana plus guns, a bunch of guns, marijuana, bigger trafficking in fentanyl or something like that. And so we don't prosecute marijuana cases unless there's this something in addition. There is automatic expungement. I know that the Bureau of Criminal Investigation, BCA, said it was going to take, I think, up to a year to get up to speed. So we are actually looking at whether we can assist that in expungement, because it's important to get this off people's records. So it's, it actually, we prosecute felonies, not misdemeanors. And so marijuana, really, I think the context in which we saw it, and we still see a little bit of it, and this is going to change with the consent decree, but a lot of law enforcement would say or use, I smelled the scent or the odor of marijuana to expand the scope of a search. And in that way, it would enable them to do additional searches, questioning, which might lead to other types of offenses. And we are very cautious about that. We tell law enforcement that's not alone okay either. Even though it might be legal in a car, it's not legal to drive with marijuana, which I do have to say, some law enforcement said, yeah, we'd pull somebody over and they'd have some paraphernalia or marijuana, and we'd say, hey, you can't have that, and they'd say, but it's legal. And so there was a lot of education that happened here. But I think this legislation is terrific. We have a long ways to go to right the miscarriages of justice that happen because of it, but this is a huge step in the right direction.
Thank you, yeah, appreciate that perspective.
Can still result in deportation. So now that folks might not be getting state convictions for marijuana, that has the potential to decrease the number of people that are placed into deportation proceedings for marijuana convictions, but it doesn't change the situation for people that have old convictions. There are also various laws in the immigration realm about the use of marijuana, and it depends a little bit on whether someone is in the United States with immigration status and their concern is keeping their status and avoiding deportation, or if they are applying for some sort of immigration status affirmatively. So if they maybe entered the United States as a refugee and now they're going to apply for a green card. And so for that reason, we are still advising people who aren't citizens that they should not use marijuana, not possess marijuana, not work in the industry, not have anything to do with marijuana until they become a US citizen or until federal law changes.
Thank you. And then, Daniel, I know you work on the housing side of it. That might be intertwined also with immigration and things like that. How has the legalization of cannabis now affected your work when you advise people as well with that?
So my work is actually kind of the mirror image of Julia's, where it is almost entirely the domain of state law. I almost always am just concerned with state law, except the small slice of housing that is touched by federal subsidies or other federal programs. my work has, like Hennepin County Attorney Moriarty said, been a lot about education. Like, we got these laws, what do the laws cover, what do they allow, what don't they allow, and taking a pretty nuanced subject and educating, regular people. Like, I would say that my work has mostly involved gentle persuasion. Homeline's main service is advice. We don't represent very many people, but we advised 20,000 people last year with a staff of like 15 attorneys and lay advocates. So we have pretty wide reach given our staff and budget. I would say the most important consequence of this has been fewer convictions, fewer felony convictions makes it far easier to find quality, healthy, affordable, stable housing. A felony conviction is one of the two most damaging things that can happen. The other is an eviction. We think there will be far, far, far fewer evictions based on marijuana use or cannabis use of any kind. But really, the evictions come with smoked marijuana because it's very hard for somebody to tell if you have an edible in your house. It really comes down to smoking or vaporizing marijuana. So I think that it's gonna take us years to see the effect on housing, but if we could somehow, my hypothesis is that if we could somehow disentangle the effects of cannabis reform on housing, you would see that Minnesotan renters, and specifically BIPOC renters, thank you for naming that disparate impact Senate report, are gonna see far, far fewer negative housing events like actual evictions or landlord-initiated displacements that are non-evictions.
Thank you. Yeah, and kind of touching on the federal versus state law, I want to know, bring it back to Senate report, what was the impact of the national movement of legalization, and knowing that, it isn't legalized federally, how does that impact the legislative side of things, and is that on the forefront of every legislator's mind?
Absolutely. I think we are very lucky to be, as a legislator who wants to learn and be able to create the best policy, we were very lucky to be the 21st state to do this. We had a lot of information out there about what had worked, what had not worked. We could learn from other states. We could learn from, in almost every state that has legalized, there has been a push for social equity, being able to lift up communities that have been most harmed by prohibition. In some of those states, it has not worked at all. Many of those states, actually. And so because that was a center point of what we wanted to do here in Minnesota, we were able to learn from those lessons. I wish we weren't the 21st state because this was long overdue. As Mary said, we should have done this before, but we had that font of knowledge to learn from, and we took that really seriously. I talked with a lot of other states that have done this work. We read a lot of other bills. We looked at how they had played out in reality, because sometimes legislation has really great intentions and just doesn't work. Really, really proud of the equity and accessibility efforts that we put in through licensing. As you are setting an industry like this up, if you get that licensing piece wrong at the beginning, it's really, really hard to fix down the road. So if we had allowed an opportunity for big marijuana, for someone who can put in millions, hundreds of millions of dollars and create a huge operation, that would be the very antithesis of what we were trying to do. So we prioritized licensing for social equity applicants. We prioritized licensing for micro businesses, which are those small, real businesses that are in your communities, rather than sort of the out-of-state guys that can come in and set up at the snap of a finger. We really avoided that by making vertical integration really hard. The bigger your business gets, there are different size differences based on canopy, based on how many locations you have, things like that. The bigger you get, the less you can do yourself. So if you're a very small micro business, you can grow and sell. If you are a larger business, you can either be a cultivator, you can be a retailer, or you can be a processor. But you cannot be all three. You can't even be two of them. And so really creating that division helped us to, hopefully, helps us as this gets implemented, to limit the ability for really large outside Minnesota producers or people with a lot of money to be able to take over the market in Minnesota, which is the lesson we took most clearly, I think, from other states. The one other thing I'll say is the number one thing we heard from other states was the two things that allowed the illicit market to really continue to expand and hold footing in other states was really high taxes on cannabis, on legal cannabis, and the opt-out provision. Having a county or a city say, no, we're not having that here. Those create just like, they raise red flags for like, hey, there's a market here that's not being served. So we did not allow for opt-outs. There is not a county in Minnesota who will be able to say, we do not want a cannabis business here. And we kept the tax rate at 10%. We were not willing to go higher than that, which puts us in line with sort of the lowest cannabis tax rates across the country.
Thank you. Yeah, and you mentioned I want to go to Hennepin County Attorney Moriarty now, because she mentioned that the sort of diversity initiatives and prioritizing maybe folks who are disproportionately impacted by the prohibition in the past, and also local growers, knowing that, and also knowing that your office might be in charge or is in charge of bringing felony charges. How does it impact your office knowing that, you know, if your office decides to charge someone, they might not have the opportunity to go into a business like that with the felony conviction that we talked about? How does that inform kind of the office perspective and speaking with law enforcement? I know you had mentioned that you don't want them only to search, you know, a vehicle based on smell, or maybe I misunderstood that. Would you mind explaining a little bit more about that piece that you had mentioned, to, you know, as you were conscious of knowing who's been disproportionately impacted before?
Yeah, I think it might be helpful for me to talk a little bit about our work at the Public Defender's Office. So when I was Chief Public Defender, we became aware that the Minneapolis Police Department was doing a marijuana sting in downtown Minneapolis. At the time, 42.5 grams possession was a petty misdemeanor, meaning not a crime in Minnesota. But any type of sale was a felony, or could be a felony. And in Minnesota, interestingly, sale actually, under the concept of sale, you can just give somebody and that constitutes a sale. Just for your personal knowledge here.
It doesn't anymore. You can
Yeah.
give 2 grams.
You can give 2 grams, okay. So here's what was happening. People were walking downtown, and police officers who were undercover would walk up to them and say, do you have any, and they were using slang, but the idea was marijuana. And I remember one particular case of a man who had, it was around Valentine, it was around this time of year. And he had a couple of grams or something in his pocket, and he was thinking, I'd really like to get a haircut for my girlfriend for Valentine's Day. So yes, I do have some weed to sell you. He then was charged with a felony sale of a drug. So the difference between being in possession of some grams of marijuana and just agreeing to sell it was the difference between something that is not considered a crime in Minnesota, a petty misdemeanor, to a felony drug sale. And so we started seeing these cases, and this was actually around the time of the Super Bowl. I think it was maybe 2017, 2018 in there. And we saw these cases come in over a period of 6 months. And what we at the Public Defender's Office noticed was that the most at the time of the people who were being arrested were Black. As it turned out, 46 of the 47 people who were charged by my current office were Black. So if you want to look at disparities there, and these were the people that the Minneapolis Police Department was choosing to walk up to. There were a couple of times when they would stand when the light rail opened up, so that they weren't targeting people that they thought were selling any kind of drugs. They would just walk up to people randomly or stand when the light rail came or people got off and said, anybody got weed, that kind of thing. But the county attorney's office charged 47 of those cases that we got at the public defender's office, and 46 were Black. The one white person actually walked up to a cop and asked, didn't know he was a cop. So a lot of things about that were our office at the time was talking to the county attorney's office saying, hey, are you aware? This does not seem fair. Sure, it's legal, but it doesn't seem fair that somebody who had a small amount of marijuana for their personal use was being asked by an undercover police officer to engage in activity which then made it a felony. And certainly at the county attorney's office, they and we have the discretion as to whether to charge. And it was like talking to a brick wall. And we couldn't get anything done. We couldn't get any movement. We couldn't get them to stop charging. And so essentially what happened is I had a meeting with the mayor of Minneapolis because I knew he had run on a platform of legalization. And I said, do you know what's happening in downtown Minneapolis? And he said that he didn't. A short time after that, MPD, Minneapolis Police Department, had a press conference announcing it was no longer going to do this marijuana sting. But there were still cases that had been prosecuted. There was actually one person in prison as a result of the conviction. And I remember at the time being asked by reporters, what do you want to see happen to all of these cases? And I said, I think they should all be dismissed, and I think their records should be expunged. That caught my predecessor a little off guard, and they ended up doing that. But it was only because of the political pressure. We were on the verge of trying to litigate those cases under entrapment, but entrapment, as you probably know, is really difficult to win. So even though this was incredibly unjust and unfair and disparate, there really wasn't a good legal defense, and it was really political action, publicity, bad publicity, that ended up in ending this and getting those convictions off people's records. So I just bring that story up as an example of how something like that can happen. And the county attorney's office at the time said, we had no idea that 46 out of the 47 were Black. And so I would like to think now, in my office, we would know that and we would take action if somebody brought that to our attention. And we would know that MPD was doing something like that, and we would say, we're not on board with that. I mean, I can't control what police do, but I can say we're not charging stuff like that. So that was really important in my kind of education about what influence we could have. And now we just would never charge those cases. But I just wanted to tell you that story because it is instructive of how this war on drugs and individual things that police do and prosecutors do can really, really harm our communities.
Thank you, and thank you for that story. I had no idea about that either. So, talking to Julie about immigration consequences, that's going to also have a disparate impact on people of color and people that come from disadvantaged backgrounds. What has your work been like knowing that, I guess either in questions that you receive or advice you're giving, knowing that maybe the Hennepin County Attorney views enforcement one way, but that's not necessarily the case in a different county or across the street or something like that? What has your experience been like that with that?
Mm-hmm. Sure. So one thing that I think might be helpful to talk a little bit about that has come up is this issue of expungements. So a lot of the advocacy that my organization did on the cannabis bill was related to expungements. Obviously expungements are really beneficial to our clients as well. They also, need housing they need jobs, they have other concerns besides their immigration concerns, but that's one area where there is kind of a disparate impact. Unfortunately, under current immigration law, expungements don't get rid of convictions for immigration purposes. So what that means is that even if someone has their marijuana conviction automatically expunged, it can still trigger immigration consequences. And that results in a couple different issues. The first is it just creates a lot of confusion. People frequently call our office and, after we explain to them that they have a conviction, that makes it unsafe for them to apply for a green card or unsafe for them to apply for citizenship. Usually their first answer is, well, I can get that taken care of, I can get that expunged. But because that doesn't have immigration consequences, we sometimes run into situations where people think that they're eligible for an immigration benefit and go ahead and apply for that benefit. But then when the immigration office sees their conviction, they're actually placed in deportation proceedings because of those immigration consequences. So we're working on doing some public education specifically for non-citizens around expungement. And then the other issue is that people still need access to their expunged records. When you apply for an immigration benefit, it's usually on the non-citizen to provide all of their records. And so we worked with the chief authors of the bill to do some mitigation around potential issues that might arise specifically on expungement for non-citizens. And so while we definitely believe that expungement can be a really important tool in the community, there are some special considerations for people who aren't citizens.
Yeah, when I was still chief public defender, that was an issue. Many of the marijuana convictions are misdemeanors, marijuana, a car, that kind of thing. One thing that we did then, we argued for, is to see if we could get the prosecuting entity, whether it was a city attorney or county attorney, to agree to vacate the conviction and dismiss the charge. I think we've done that at the county attorney's office, and I'm just saying, I know we would be open to that idea on a felony marijuana conviction, looking at that, if it did cause immigration consequences, looking at whether it makes sense to vacate the conviction and dismiss the charge. So that's another way around that.
Would you mind elaborating for folks who may be not so familiar with the criminal justice system, why that would be beneficial in an immigration context?
Sure. Well, I would defer to immigration expertise because immigration law is very, very specific. In fact, I used to go to immigration seminars and I would walk out of there understanding that the answers were, it depends. And it changes all the time too. And so when I was chief public defender, I hired an immigration lawyer to work for the office to work with all of our staff to be able to advise them appropriately on potential immigration consequences. So when I say that, our idea in criminal law about pleading guilty or convictions is very different than what immigration law is. So immigration law sometimes perceives a conviction as something that we would never, like if somebody says, I am guilty of this on the record, even though it didn't end up in a conviction, that acknowledgement, that admission can be used in some immigration cases. But in terms of the issue I was just talking about, expungement, as you said, the federal government will still look at what was said, the conviction. They don't care about expungement, right? But they do care sometimes if it's a criminal conviction, especially a felony under certain, it's very complicated and I would defer to you. So rather than agreeing to expunge the case, we can, as prosecutors, say, there is a reason to agree with you, the defense or immigration lawyer, that this conviction should be removed from somebody's record. And what you have to do is go back and get a judge to sign off on what the word I used was vacating the conviction. So taking the conviction back, and then the charge is still there. But then we would agree not to pursue it. In other words, we would dismiss it. So you have to undo the conviction, and then you have to make the charge go away. And if you do that, then you don't have to worry about expungement, or you don't need an expungement, because an expungement is actually essentially sealing the records of the conviction, okay? But there's no conviction anymore. Also with expungement, you can't undo something that's in the press. And this is one thing that we talk to our staff about too, when we are considering charging anything. Don't just charge something and decide we can take care of it later. We talk about this on drug cases all the time. We now have access to body cam and video that we can look at and should be looking at to make sure that what is in the police report actually matches, or what's in the video matches what's in the report. Not because police are intentionally making stuff up, but human memory being what it is, sometimes it's very different. So we want our people to be looking at the video, looking at the stop and the search before deciding whether to charge. Because even by the act of charging, that can be out there in the newspaper, social media, who knows what. And that's something that can be used against people as well, even if they get it expunged.
Thank you. Yeah, Julie, do you have anything to add about the immigration?
Yeah, the only thing I'll add is that that's correct, that if someone gets their conviction vacated, it's possible that it will no longer have immigration consequences. There is some specific case law that the conviction has to be vacated for some sort of substantive or procedural defect rather than just for rehabilitative purposes. So it's not enough, for example, if the judge says, I feel bad that you're having immigration consequences now, I'm gonna vacate your conviction, you haven't gotten into trouble in years. So it would be a process of, looking at the conviction, working with the county attorney if they were open to it, to identify a possible procedural or substantive defect that would work for immigration.
Thank you. And then, Daniel, for housing, has that affected, I know you said it's mostly state law, so how has that affected, maybe people think that they can't qualify for certain housing, and they have housing issues when they should be available because of an expungement or something like that? How does that kind of interact or how does that come into play when you interact with folks?
So I said I think I told Julia that I wasn't going to talk about this law, but I'm going to talk about the Quality Housing and Work Responsibility Act of 1998, part of the grand bargain of neoliberalism. President Clinton continued the work of Nixon and Reagan in trying to reduce access to government benefits and specifically government subsidized housing. The QHWRA did prohibit the receipt of benefits, not just for the conviction of a cannabis offense, but like the consumption of controlled substances, period. And that really affected people's ability to get into public housing or even other forms of federally subsidized housing like Section 8. The newly created at that time LIHTC or Section 42 program. Those are all federal programs that are completely exempted from the state cannabis law. And just to real quick say, if a tenant in Minnesota lives in federally assisted housing, and the big ones are Department of Agriculture, rural housing, Section 8 of any kind, Section 8 project, Section 8 voucher, LIHTC, or public housing, the state law does not apply. They cannot use or possess cannabis products in their property. They can be barred from applying or even be evicted for cannabis-related offenses, even if it's perfectly legal under state law. And I like to tell people, not knowing about the average person can walk around in their life and know nothing about federal conflicts preemption or spending clause contingencies, and that's a good way to live for most people, but it really affects the people who need our help the most. And you have to be pretty poor to live in government subsidized housing. Like for an individual person, you have to make $18,000 a year or less. For a family of two, it's $24,000 a year or less. So you have to be really, really poor. And these tenants tend to be disabled. They tend to be people who have suffered the generational harms of institutional and structural racism and who have been locked out of economic opportunity. A lot of them are immigrants and people who have become legally naturalized but have left behind their support network and their economic well-being to come to America for their safety. So those are the people who are left vulnerable, and there's a lot of misconceptions about this. I spend a lot of time explaining federal conflicts preemption to regular people. And sometimes they don't believe you, and it's really difficult to empathize and say, like, you know, Hennepin County Attorney Moriarty pointed this out, like, it may be unfair, but it is legal. You know, and so that's a big distinction that can be really hard for people to swallow, especially when it's your home. You probably like your home. You don't feel any different than anyone else just because you live in subsidized housing, or I would hope people don't. And that's what we're trying to achieve, but you are locked out of this one opportunity that has been opened up under state law.
I want to take some time if anybody has any questions. I know we're at 1 o'clock and we're scheduled to end at 1:15. So if anybody has any questions for any of our panelists, I have more questions, but if anybody feels so inclined. So, yeah.
I have a question, maybe it's best for Senator Port. So I grew up in Washington State, and weed has been like legal for many years. Before that, it was medically legal, and it just looks very different. Like the weed shops are all like boarded up, and they look very dark. It sort of like feels illicit, even though it's legal. And I just had a different experience in Minnesota since like, I mean the gummies and the cafes, and then now with legalization, it feels much more like out in the open. And so I wondered, like, from your perspective, like, what is it about the Minnesota bill that makes it kind of look that way?
Yeah, that's a great question. I think a couple of things come into play with that. First, Washington was one of the first states to do this. So they had a very sharp path from an illicit substance that had a very strong stigma attached to it to legalization. And that resulted in like a lot of security requirements, not visible from the street, things like that, because it was still, it's like, we don't want to perpetuate the harms, but it's still like, it's still like something bad that we kind of like don't want out there for, you know, kids to see weed because, oh my God. And, you know, we have a decade of national exposure to legalized weed that we could build on. We also have the smallest medical marijuana program of any state that has legalized. So we had really a very, very, very specific and very small medical marijuana program in Minnesota. So the ability to sort of go from like, well, in California, anyone could get a medical marijuana license. Like if you have a headache, you can go and get a medical marijuana license. That is not true in Minnesota. So we don't have that infrastructure. The thing we do have that no other state has is we legalized low-dose hemp gummies and beverages the year before we legalized cannabis. And the sky didn't fall. I think like I cannot overstate a bill that I had no part in, had done no work on, massively impacted the ability for me to pass the legalization bill because the sky didn't fall and moms in the suburbs were taking gummies to go to sleep and people could get THC beverages at their local bar. Like it was visible, it was something that they could relate to, it didn't feel scary, it helped like lower, just cut through a lot of that stigmatization. And time too, right? Like weed's been legal in nearly half the country for over the last 10 years. And I think people have seen that, you know, Washington isn't just like a whole bunch of people sitting on their couches eating Taco Bell. Like it's got one of the best economies in our country. It's a big industry. So all of that to say, also, you know, really glad we passed the low-dose hemp edibles bill before. Could not have anticipated how much that helped move the legalization conversation forward.
So I think this is a question for Attorney Moriarty. So I know that the police are implementing a pilot program to test drivers who are going to be, who they think might be driving under the influence. Do you know what sort of like legal implications that will have for probable cause? I know that they can no longer search someone just based on smell alone, but I guess like in this new territory, do you know what is going to be a probable cause, or like I know that this hasn't been, you know, it's only a pilot program, so we're not sure what the effects are going to be, but if you just had any insight into what the legal implications of that would be.
Yeah, that's a great question. I think one of the areas where, I would say the area of biggest concern for law enforcement was driving under the influence of marijuana or any drug. And I have to say, in January of last year, I got rear-ended by somebody who was high on weed. And I know this because he came up to my window and then drove away. So it was a hit and run. And so, you know, the public safety implications of that are huge. And I want to tell everybody here, do not drive under the influence of any drug. Just don't do it. But up until now, and it's been, you know, you can't be driving under the influence of any drug, but it's somewhat difficult for law enforcement to be able to determine and actually prove, or us to prove in court, that the person was actually under the influence. You know, were they just tired? I mean, we've had blood tests for alcohol, and so that's, I would say, has made it easier, but that's also been challenged by defense lawyers, that the various types of breath tests, that kind of thing, have always been challenged by defense lawyers. There's something called a drug recognition expert, a DRE, that I think many defense lawyers would say is not scientific, and they don't believe that. But those are specially trained law enforcement officers who put somebody through a series of tests and say that they can determine that somebody is under the influence of some kind of drug. So I think we're really at the beginning of what is it going to look like. I mean, sometimes it can be fairly easy. If an officer is behind somebody who's weaving through the lanes, or there's something about their driving behavior, and they get them out of the car and they can't, I mean, they're under the influence, they need to, and this is one thing we've been training on, you need to say in your report exactly what you observed. You can't just say, well, I believe this person was under the influence of something. Well, why? Why? And with video, that can be helpful. But this is an emerging area. As you mentioned, the pilot program. I'm interested in seeing how that pilot program goes. I know defense lawyers will be challenging this. We will have to take a hard look at it to see, is there science underneath this? Do we feel comfortable relying on this? But that's just going to be an emerging area. But I will say it has been a shift in focus for law enforcement, and we have somebody who works with law enforcement, and we're trying to, is really emphasizing to them, because we've seen this a lot. You smell the odor of marijuana, and yet you didn't do any testing about the driver. And I think somebody driving under the influence is far more dangerous than somebody who might have drugs in their car, which is what they end up, you know, expanding the search and finding that. So focus on the public safety implications, which we don't want drivers who really shouldn't be on the road. So we've tried to emphasize that with law enforcement. Focus on these driving under the influence cases, but it's a huge shift in the culture for law enforcement, and we have yet to, I mean, I know this will be challenged in court. It remains to be seen how that's going to turn out.
Can I add to that? First of all, the pilot program cannot be used. Anything that happens in the pilot program cannot be used to charge anyone. So after the pilot program, I'm certain there will be a bill brought forward to try to expand that, to make it a legal thing that can be used to charge, but we're not there yet. The other thing, I will say, this was a huge point of contention in the legislation. The point I kept making and will continue to make is it is illegal to drive under the influence. It's not illegal to drive under the influence of alcohol. It is illegal to drive under the influence. And people do it all the time, on Ambien, on NyQuil, on marijuana, on alcohol, on all sorts of things. And so my main focus on that was really the public safety aspect. We want to limit that behavior as much as possible. So we put a lot of money into education. You will begin to start seeing billboards and outreach and things like that across communities to help educate people that like it's dangerous to drive on cannabis. We want people to know that and to understand that and to make that decision. Just like, you know, there have been anti-drunk driving education for years, though clearly not super effective. Like, I believe the more we can do on the education front rather than the punitive front is the most likely path to help us. The other thing I'll say is this is going to be exactly, as Attorney Moriarty said, an emerging area of law. And the thing we tried to do with this bill was take our very best shot at the first bill. And in the Minnesota legislature, nearly every year, there's some sort of liquor bill. Whatever, you know, tweak here or there, Sunday sales finally passed, you know, like bit by bit, prohibition of alcohol has ended 100 years ago. And we're still tweaking alcohol law every single year. This is the first cannabis legalization bill, and it is going to have hundreds of industry-wide tweaks to this kind of law. So the number one thing that like we have to remember is we need to continue to engage community in the same way that we did with intention on this bill. That is how we should make policy moving forward, and that's how we'll actually find ways to limit behavior that we don't want rather than to just punish, which is most likely to be done in an unfair way.
And you know, just to add to that too, one of the biggest surprises I had as county attorney is the number of what we call criminal vehicular homicides. And those are people usually drinking, sometimes not paying attention because they're looking at their phone. And in one split second, they go through a light, they kill people who are just going about their business. And those are absolutely devastating cases for both the victim, obviously, and their loved ones, but also for that person. And so we have a big problem with people driving who are using alcohol. And as the senator said, that has been illegal. It is illegal to drive under the influence of alcohol, drugs, anything. And so I think this has had, and I'll go back to it, a particular cultural issue. You know, at some point it was decided that marijuana was more dangerous than alcohol. And so we were going to criminally punish it in a way that we have not done with alcohol. And we are seeing the consequences of that.
County Attorney Moriarty's point. Your landlord can still ban smoking and vaping. That is unaffected. That is kind of just a standard lease covenant thing. The law specifically says that a landlord can, in fact, ban smoking or vaping in a rental dwelling. That said, your landlord cannot restrict your ability to possess cannabis products in the, as long as they are within the legal limit, within a rental dwelling. So you can possess and use cannabis products, which is separate from flower under the law. So those are just your edibles. And I think that's my hypothesis is that's going to be the real growth area for the state is the use of edibles rather than smoking and vaping. I'm young enough, or old enough rather, to remember when smoking was like legal in restaurants and things like that. And so my life has sort of tracked the public health campaign against smoking, and that is somebody who's quit smoking 3 times personally. Like, it's a very positive development for society. But one of the things that, for, again, standard market rate housing, there is an exception for smoking, and this existed before. For medical, you can get a reasonable accommodation to smoke or vaporize cannabis flower. Besides that, I mean, there is, the one question I have, and this is an emerging area of law, is whether a landlord can prohibit the prohibition of flower, cannabis flower, the legally defined term, in market rate housing. There's not a specific non-waiver provision in the law, so it's one of these like, the Airbud rule, like there's no rule in the book that says we can or can't. So that's what I refer to it as. And so it's not clear whether, to me, maybe Senator Ford can clarify, whether a landlord can prohibit the possession of flour in a unit. They can't prohibit anything else. That's the one area where I'm not sure whether a landlord can waive it or not. No, I'm sure we'll find out soon.
I can say specifically that it is not in the law purposefully, because there was considerable pressure to make stronger bans on where people could consume. And we knew if we specifically called out that that landlords could not ban it, we would open up a fight that would push for stricter regulations. So by staying silent on it, we didn't paint a target on our bill that would have allowed an attack that I really did not want. As the housing chair, like, this cross-section is super important to me and is a piece that I will continue to work on, because I think housing discrimination and fair housing in general, we just are a complete and utter failure at. And so this is very much, it's a cross-section. We tried to be as quiet as possible about what we put in the law, knowing that we have great partners like Homeline who will help advise people, and we didn't want to put a specific restriction on. I'm sure it will be litigated. I'm sure landlords will try to do some of that. Read your leases carefully and make sure you understand what you're signing, because they do have the ability to go beyond what we said is legal and not, before you sign a lease.
And it is worth pointing out the Minnesota Clean Indoor Air Act already prohibits smoking of any kind, marijuana or tobacco or whatever, in the common area or on the premise of any rental dwelling of more than 3 rental units. So there's already a lot of restrictions in place against smoking on property. And I know I went a little long, but I just want to say, I do wonder about the effect this is going to have on discrimination law. Like neighbor complaints about smoking. Anecdotally, I haven't run the numbers on this. It'd be hard with our data for attorney-client confidentiality reasons, but every time I hear about somebody, a client of color says to me, I don't smoke pot, but somebody on the floor does, and I'm getting blamed for it because I'm black. Or a neighbor, and sometimes they're my client, they're not particularly sympathetic in this way, where they're saying, I'm bothered by marijuana smoke, and I know what neighbor it is, and you kind of know many times the implication that has. I do wonder how this is going to affect discrimination law, and that is completely open. I could see a way in which it causes more discrimination issues. I could see a way in which it alleviates certain pretextual displacements based on racial stereotypes about cannabis use. So I have no idea how that's going to go. I hope the Minnesota Department of Human Rights is studying that, because I think it could be very, very important to future efforts to refine that intersection of discrimination law and cannabis reform.
Great. Thank you. And I just want to give a round of applause for all our Thank you all for being here. Thanks to the audience, and we'll wrap up. Yeah.
If you're attending